Hey everybody, it's Yolie Medina, civil attorney. So I wanted to go over one of these, the state's motions in limine on the Bryan Kohberger case that hasn't been talked about too much, or at least I haven't seen it been talked about. And let me just briefly, for those who might be watching for the first time, this is a case where Bryan Kohberger is alleged to have unalived 4 students near the University of Idaho, in a house near the University of Idaho. And it was Kaylee, Maddie, Xana, and Ethan. And they were beautiful young adults, and they were slaughtered, basically. And so, the defendant, Bryan Kohberger, we've heard rumors, we've heard information from his aunt that he was very particular. He didn't like pans that had touched meat. If the pan has touched meat, he didn't want to eat off of it. And then we heard from his neighbor that he used to vacuum at night. And she knew this because she had a newborn and she was afraid that the vacuuming would wake up her newborn. So she had a specific memory that this would occur on a routine basis. So the state brought a motion in limine, and that motion in limine is generally used to exclude things, but it can also be used to get a ruling in advance to admit evidence. In this case, the state has brought a motion in limine to exclude Bryan Kohberger, the defendant's, neuropsychological and psychiatric records. Okay, so let me put that up on the screen. So here we are. It's the state's motion in limine neuropsychological and psychiatric evidence. So the state wants an order prohibiting Bryan Kohberger from offering testimony regarding neuropsychological evaluation and psychiatric evaluation of the defendant as summarized in defendant's January 23, 2025 supplemental response to requests for discovery regarding expert witnesses. So during the discovery process, when they're disclosing expert witness information, the defendant, Bryan Kohberger, gave some information that he intended to produce neuropsychological and psychiatric evidence by way of testimony. And there's medical records, apparently, that these experts are relying on. So the state is saying that a mental condition, it says basically, in support of this motion, the state respectfully refers to the court to Idaho Code Section 18-207, which provides that mental condition shall not be a defense to any charge of criminal conduct, except expert evidence on the issues of any state of mind, which is an element of the offense. Okay, so the prosecution is saying that in each of the witnesses' summaries, the defendant specifically states a testimony is not intended to be a mental element defense pursuant to Idaho Code Section 18-207, but rather this testimony is about state of mind as well as a factual defense testimony to anticipated testimony elicited by the state. And they say this testimony falls outside of the mental condition evidence allowable under Idaho Code Section 18-207, parentheses 3. Okay, so, when I read this, I wasn't sure what to make of it. Not until I could see everything. So the defendant filed a reply or an opposition or response, however you want to call it. Defendant's response to state's motion in limine regarding neuropsychological and psychiatric evidence. Okay, so apparently I highlighted this because Mr. Kohberger has filed several related motions that will be argued concurrently with this motion. So they refer us to motion to strike death penalty autism spectrum disorder, motion in limine number 4 regarding using the terms psychopath or sociopath, and then motion in limine 13, conditions as an aggravator. Okay, so generally what happens is the defendant in a death penalty case has a mitigation phase where if he is found guilty, then the court or the jury gets to take into consideration mitigating and aggravating factors. So one of the mitigating factors, if Mr. Kohberger does have autism spectrum disorder and a number of the other conditions that are talked about in their disclosures, the expert disclosures regarding neuropsychological and psychiatric evidence, they talk about an obsessive compulsive disorder and also motor coordination disorder of some sort. But in any event, so the response by the defense to the prosecution's motion in limine to exclude this evidence says, this response is made pursuant to due process, Idaho Rules of Evidence 106 for a complete defense and a fair trial guaranteed by the 5th, 6th, and 14th Amendments to the United States Constitution and Article 1, Section 13 of the Idaho Constitution. So it goes on, and this is what's interesting to me. This is what the defense is saying. The minute that jury selection begins, jurors will begin to study and analyze Mr. Kohberger's physical presence. They will watch his every move and pass every judgment on him every minute of the jury trial, simply based on how he looks and reacts to the presentation of certain evidence and comments about him. Mr. Kohberger must be able to present testimony to the jury that he has certain physical disorders. It will assist the trier of fact to know his physical presentation, including nonverbal reactions in the courtroom, is explained by his physical condition. To exclude this evidence will result in unfair bias that could cause a wrongful conviction. This objection is supported by the declaration of Jeffrey Lewine, an expert in neuroscience and neuroimaging. So this expert has provided a declaration. So it says, Mr. Kohberger in no way suggests that expert testimony related to his autism spectrum disorder, obsessive compulsive disorder, and developmental coordination disorder are for the purposes of showing that he does not know right from wrong. He has at all times and continues to assert his actual innocence in this case. The state correctly noted in its motion, Mr. Kohberger's disclosures state that Dr. Orr's testimony and Dr. Ryan's testimony is not intended to be a mental element defense pursuant to Idaho Code Section 18207, but rather this testimony about state of mind as well as factual defense testimony to anticipated testimony elicited by the state. So they say, the defense says, Idaho Code Section 18207 is not limited to the admission of either direct or rebuttal expert testimony to the elements of the crime. And they cite a case, State v. Samuel. And that's an Idaho case, 2019. And it says, because of the statute's broad application, the Idaho Supreme Court has determined that Idaho Code Section 18207 applies to legal proceedings before trial, including pretrial motions. Okay, so the State v. Samuel case was about somebody who was arrested, and there was a question as to whether he understood his Miranda rights because he had some sort of disability. So in this case, what the defense is wanting to do, let me go down to, the defense is trying to say that autism, well, not trying, is saying through an expert that autism spectrum disorder, which is a neurological disorder, is associated with structural and functional physical defects in the tissues of the brain that can't be seen when you look at a person, but can be observed with proper microscopic examination, and in some individuals through the use of quantitative analysis of magnetic resonance imaging of the brain, such as the case with Mr. Kohberger. Now, so what the defense is trying to do is they're trying to say that Bryan Kohberger has a physical has physical defects associated with his autism spectrum disorder, and that this can be proven by, imaging of the brain. Okay. Now, head scratcher here is, here's the head scratcher. The defense wants to instruct the jury to tell them about Bryan Kohberger's disability, to explain how he may react to evidence, why he has a stoic stare, and other things. But I'll read it just because I want to be inclusive. As a physical condition, ASD may not be noticeable as some physical conditions like missing an arm. If Mr. Kohberger had the physical disability of missing an arm, the jury would not require explanation about how such a physical condition may impact the case. Autism spectrum disorder is visible in some ways that will be apparent to a jury but requires explanation. Okay. Without explanation, the way that the public perceives the behaviors and mannerisms of someone with autism spectrum disorder is not always favorable and may be prejudicial. While Mr. Kohberger's presentation is highly consistent with autism spectrum disorder, without explanation, others may misinterpret and misidentify Mr. Kohberger's behaviors and cast them in a more sinister light. For example, he does not show emotion on his face. He has a flat affect. He sits very still and holds his hands in the same position. He has a piercing stare. He does not show expected reactions. Facial expressions do not reflect what he is feeling. He is stiff in body posture. He has prosody in speech. And prosody in speech, I had to look that up. I don't remember what it is. But anyway, he has prosody in speech. He uses repetitive phrases and large words. Has developmental dexterity problems. Many of his behavioral characteristics are known to be commonly associated with the presence of autism spectrum disorder and are clearly relevant to the interpretation of his behaviors in the courtroom by the jury, and may also be relevant evidence regarding the rebuttal of evidence as to the commission of the crime itself. Further explanation about autism spectrum disorder by the United States Government National Institute of Mental Health is helpful. And so it gives a description of the behaviors that people on the autism spectrum display. And then it talks about obsessive compulsive disorder. And basically they're saying, the defense is saying that it's one, obsessive compulsive disorder also goes hand in hand with autism spectrum disorder. So it goes on to say, Mr. Kohberger has sleep difficulties and subsequently developed a habit of night driving or running to decompress, such behaviors being present most of his life. So that habit, again, is coming up. And I did a video regarding Bryan Kohberger's alibi and the issue of habit evidence. That habit evidence can sometimes be used to corroborate, not establish, but corroborate with other evidence an alibi. Because in this case, they have a white car driving around, and I can't tell. There's no license plate that is captured that links it to Bryan Kohberger. But in any event, there's a white car driving around at night. And so what the defense is saying is that he has a habit of night driving or running to decompress. And for the most part, you know, I've worked with people when I was a mental health worker. Also, I represent children who have birth injuries and who have disabilities, such as the ones that they're talking about with Mr. Kohberger. And, you know, there's a reason why people, when their babies are colicky and they're crying all night, there's a reason why they put them in the car and drive them around. It's because it calms them down. They fall asleep. There's something soothing about driving around. I'm not implying that Mr. Kohberger was doing that for that reason, but there is such a thing. So that could explain his habit of night driving or running to decompress. Okay, it says such behaviors being present most of his life. Those behaviors were present most of his life. So what I would expect is to have somebody front that is known in most of his life to say, yes, he's always been driving around at night. He does these behaviors. He goes out running at night, or he does these things. Okay, then it says he also engages in frequent compulsive hand washing, wears gloves to avoid germs, has a fear of things getting into his eyes, changes his shower curtain frequently to avoid exposure to mold, and avoids anything he views as contaminated. So, if the state elicits testimony at trial related to these types of facts that are used to build circumstantially the elements of the crime or to show Mr. Kohberger's actions as reflecting his state of mind or other elements of the crime, he will refute that evidence through expert testimony as behaviors related to his OCD and autism spectrum disorder. By way of specific example, the state has continued to claim that Mr. Kohberger was wearing gloves on the night of his arrest and placing trash in baggies. The state asserts this demonstrates that he had a consciousness of guilt and was trying to either hide his DNA or engage in the cleaning of his car. Okay, but what you need to know is these crimes were committed on November 13th, 2022, and Mr. Kohberger was arrested on December 29th or the 30th of 2022. So a month and a half had already passed. So why they would be thinking that it would show consciousness of guilt if he was wearing gloves on the night of his arrest and putting trash in baggies, I don't know. But apparently that's what caused the SWAT team to think that he was going to hide evidence, which he probably would have done that a long time ago if he was going to hide evidence. And that's why they busted into his house and busted windows and came in with the SWAT team, 50 people there to arrest him. So anyway, so what they're saying is that if that evidence is introduced about how they went into his house and what he was doing, with I guess there were kitchen gloves, and apparently he was, according to the defense, he was cleaning his bathroom at night. But anyway, and then he went to his car, and then he got something and went to the sliding glass door or something like that. And apparently when they arrested him, they found some green leafy substance. But anyway, among other things. So while testimony related to these topics may not be relevant until the state opens the door by eliciting testimony on these issues, once it does, Mr. Kohberger must be allowed to provide expert testimony refuting the state's witnesses, so it can help the trier of fact in evaluating circumstantial evidence the state may put forward. And since all such testimony would be subject to vigorous cross-examination, it would clarify and not confuse the jurors. So the other thing they're saying is that Mr. Kohberger suffers from deficits in fine motor dexterity and visual motor function. Now, we do know that he has visual snow, which is something like a film over your vision, over your eyes, that causes you to see kind of like static TV. He's had that for most of his life. And then he also, according to this, has fine motor dexterity problems, deficits. So the defense is saying clearly these are physical issues. So he has experienced these physical impairments all his life. The state has disclosed evidence that law enforcement will testify that they did test runs at the 1122 King Road home, and that it is possible to commit 4 homicides in a time frame of only minutes, including walking to and from a car and removing clothing that would be covered in blood. So additionally, the state has disclosed forensic pathologists who will testify regarding the manner of death, injuries, and specific wounds on the deceased. So Mr. Kohberger has disclosed a forensic pathologist who has some differing opinions, including injury and specific wounds on the deceased. It will be relevant for the jury to know that Mr. Kohberger has a developmental coordination disorder that impacts his fine motor dexterity and visual motor function. Such speed and coordination are not possible for him. So now the defense is saying that based on these deficits, which are developmental deficits, and when I say developmental, that means as he's growing up as a baby to the time that he becomes a preteen, he may have had issues with fine motor function, coordination issues, and things of that nature, which he maybe had. But, as time goes by, And I only know this because I work with babies and children who have these types of symptoms. They learn to adapt. So Bryan Kohberger was 28 when this happened. So I'm not sure that this helps him in any way. And it might cause some people to not buy it. Like, I don't buy that. Because he used to run. I mean, he runs, he's a runner, he did boxing. He was overweight in his high school years and he lost tons of weight. And he was pretty much running and hiking and doing all these things. He had stamina because he could run. I mean, I don't know, his Strava, I guess that's some kind of app that you use to rate your physical function. I don't know. He was running very fast, and I think he ran a mile in 6 minutes, or I'm not sure exactly, but it was fast. He ran fast. And so the fact that the defense wants to actually tell the jury ahead of time that Mr. Kohberger suffers from these physical impairments and impairments in the way he reacts to evidence and the way he might seem stoic. I'm not sure that's going to fly. I'm not sure the judge is going to allow an instruction to the jury before the trial starts that Mr. Kohberger has this disorder, and, do not put any weight on the fact that he may not respond to evidence. Do not put any weight on the fact that he sits there and looks completely fine and doesn't have any, emotion. I don't know that that's going to work. In these, when I think about this, I think that those types of instructions are given when somebody has, like, for example, Tourette syndrome, where they say the F word every 15 minutes. F word every 15 minutes, it can't help it. That might need to be explained to the jury so that they understand. Or if someone has, like, a neurological disorder like Huntington's chorea, which is involuntary movements that cannot be controlled. Maybe the jury needs to understand that. Maybe a pretrial instruction that, so-and-so has Huntington's chorea. It's a condition that causes involuntary movement. Please do not be distracted by that. It's normal for him, blah, blah, blah. But this trying to turn autism spectrum disorder, obsessive compulsive disorder, and developmental coordination disorder into some kind of a physical defect that needs to be explained to the jury, I don't know if that's going to fly. Because Mr. Kohberger has been in hearings that lasted days. I mean, he sat there, and he sat there he just sat there. And one of the reasons why cameras were initially barred in the courtroom, or not initially, but there were cameras in the courtroom and media was, videoing the proceedings, and they were focusing on things like his zipper. They were focusing on things like doing close-ups on his face, and you could see sometimes that his jaw would move, and it was the judge was very upset about it, and he banned cameras. Then he said, well, he took control of his courtroom, and he said, well, I'm going to put a camera and it's going to be streamed on YouTube. And so the prior judge, that's what he did. And that's continued with the judge that he has now, because the case was moved in a change of venue motion. So I don't know what you guys think, but this is interesting to me, because I don't think I've ever seen this before, where a disorder that can be seen in imaging. I have no doubt that there are changes in his brain, or his brain has some evidence that it has some dysfunction or deficit. But when somebody is sitting there in a trial and they're not on the stand, that's not evidence. So to make a ruling or give an instruction based on how the defendant looks while he's sitting there, I don't know how that can be done, because the jury is only supposed to consider what comes from the stand or what documents or evidence that is brought into the case. And so if Bryan Kohberger never takes the stand, the jury does not need an instruction about how the defendant or why the defendant is sitting there, because basically that's all he's done, is sit through the hearings. I mean, we can't tell anything about him. He's just sitting there. So because we also have that not evidence, but because we also have that video of him sitting through the hearings, long hearings, 2-day hearings, and he hasn't caused a disruption. He hasn't done anything. He looks like a normal person that's just sitting there trying not to show any reaction to me. So anyway, I thought this was a very interesting motion, and there really is no law that allows for this type of thing, other than the common sense instruction that would be given if somebody has like Tourette's syndrome, where they're going to be, or involuntary movements. So I'm interested in how the judge is going to rule on this, and I hope it doesn't backfire on the defense, but it might. It might be seen as a last-ditch effort to try to precondition the jury to feel sorry for Mr. Kohberger that he has these disorders. And it might not come in. I mean, the judge might be upset about it. I don't know. But it's a very interesting motion for me. And I think that this motion or this type of thing that they want to do is instruct the jury on what he's like and what to expect with him sitting there in trial is not, I don't know if that's going to fly. But in any event, the defense, they replied to the state's, the prosecution replied to the defense's response to their motion, and they proposed something reasonable, which let me show you what they proposed. So first of all, they state, as stated above, the state is unaware of any authority that would allow the defendant to present evidence purportedly explaining how he may appear or behave in front of the jury. And then it also says there's, however, a body of law regarding prosecutorial misconduct holding that a defendant's courtroom behavior off the witness stand was legally irrelevant to the question of his guilt of the crime charged. So that's what I was saying, is it's irrelevant to whether he committed the crime or not. Let's see. They proposed something here. Sorry. Okay, so the state asked the court to enter the orders in limine as follows: prohibiting the defendant from offering evidence of purported explanations of how he may appear in front of a jury. This is irrelevant and immaterial, is most likely to appeal to the sympathies of the jury, to mislead and cause confusion on the real issues in the case, which are whether or not the defendant is guilty of murder and burglary. And then reserving ruling on whether the defendant is entitled to offer rebuttal evidence of his mental condition to the extent that it might be offered as an alternative explanation to any of the state's evidence about the defendant's suspicious, unusual, or otherwise odd physical and social behaviors. And then it says, deny the defendant's introduction of the newly disclosed evidence regarding his physical condition, which was not previously disclosed, nor proffered as rebuttal or response to state's guilt phase expert disclosure, and which on its face does not appear to be relevant. So again, this neurological and psychological or psychiatric evidence might be relevant for the mitigation stage if he is found to be guilty. But for the guilt phase, I think this is a fair proposition that that the defendant is entitled to offer rebuttal evidence if, in fact, The state introduces evidence that he's walking around with gloves, sorting the trash, driving around at night, vacuuming at night, doing these types of things. So I think that's fair what the state is proposing. So anyway, well, those are my thoughts on this motion, and I didn't see a lot of people covering it. I think I saw, I don't know, I saw something, but I didn't see anybody covering it. So I thought I would talk about it. So you guys let me know what you think, and be nice in the comments. You don't have to be rude. And keep it civil. Anyway, I'll see you guys on the next video.